It's no secret that cyclists often have problems with drivers, particularly with respect to safety, and therefore they carry and wear and use cameras either on their helmet, the front or rear of their cycle, or all three. And in doing so will catch drivers either doing a close pass, which is not a strictly defined offence, but it would come within driving without reasonable consideration for other road users and attract penalty points and a fine. And very often they film drivers on their mobile phones, which attract 6 penalty points and a fine, and the fine is often higher if unsuccessfully challenged in court, because they've wasted the court's time when they were quite clearly filmed with an illuminated screen inside the car. And if I could ask you one teeny tiny little favour and hit that subscribe button below, it doesn't cost you anything. I'm not asking you for any money. It's all free. You get all my content here for free. I've been doing it for years now, but it's the one thing I do ask of you, because it's the one metric that shows me that I'm reaching a wider audience. YouTube will promote me to more viewers, and I like seeing the numbers grow. So please do that and enjoy the video. But this gives rise to many questions such as, aren't the cyclists breaking data protection law? Don't they have to comply? Why are they allowed to film other drivers whilst out in public? The broad answer to that is no, they are almost certainly not breaking data protection law for one of a number of reasons, which I'll go into in this video. And one of the reasons is that out in public, you have no automatic expectation of privacy, and there are some more specific reasons they're not breaking the law, one of which is an exemption, and the other is if the driver is filmed doing something wrong and the cyclist in turn reports that footage to the police and they get prosecuted, there is no confidence in iniquity. In other words, if the driver is caught doing something wrong, then there's nothing to stop the cyclist. It would be against good public justice to prevent the cyclist from providing that footage to the police. Bearing in mind, if the cyclist films themselves or the footage shows themselves doing something wrong, they might too be prosecuted for that as well, as I recently covered in another video. But nonetheless, if the driver is filmed, that can be reported to the police, and the police will then prosecute if the evidence is sufficient that there is a realistic prospect of conviction based on that footage. But to data protection law, this overlaps somewhat with my video on, or videos on, CCTV, static CCTV such as Ring doorbell cameras and other CCTV you have at home. And many people said, well, what's the difference between CCTV at home and dash cams and cameras out in public? Because you're filming people, members of the public. Now, it's a valid question because on the surface it sounds very much the same. But as confirmed by the ICO, their view, the UK's data regulator, they apply specific rules to CCTV, domestic CCTV, which I've covered in many videos, which very broadly speaking, if you're using a fixed camera, it ought to be within the boundaries of your own property. And moreover, the audio recording shouldn't really be picking up audio from outside the boundaries of your own property. If it does, then you do need to comply with the Data Protection Act for the broad spectrum that it applies. In particular, the amount, the duration, the frequency with which you capture people outside that are identifiable outside the curtilage of your property, and in particular the audio, because as I've said in previous videos, if you catch conversations of people in their garden, there is a reasonable expectation of privacy for them in their own garden. So you might well be in breach of the Data Protection Act if you capture more than is reasonably necessary. And certainly if you use it for any purpose other than that which it was recorded for in the first place, the only one of which really is going to be security. So for example, if you film something in your garden, you catch your neighbor, you put it online because it's funny, that is likely to be in breach of the data protection legislation. But the ICO distinguishes those from what they call here roaming cameras, such as drones and dash cams, and they will also incorporate within that, in my view, not speaking for them, but in my view, they will also incorporate that any kind of GoPro or DJI action cam that people have out in public, because they are roaming. The distinction being they are not fixed, they are not static, they are not permanent. a permanent CCTV at your home is permanently trained on a given area, and it is monitoring that area 24/7. Motion detected usually, recording and storing usually in the cloud, etc. So that is distinct from dash cams, drones, and other roaming cameras such as GoPros and DJI action cams. So, to data protection legislation, how do cyclists, or how could cyclists get away with this? Many of you cyclists that are watching this might wonder, are you okay filming this outside? Now, not that this can be taken as legal advice, but certainly it can be taken as guidance from me as a barrister, and I can go through why I think it's perfectly okay. Drivers that are angry that are watching this, I'm sorry to inform you that they're not doing anything wrong. There will be some circumstances where I think it will cross a line. For example, if you had a child in the back of the vehicle and the cyclist was pushing the camera into the window to film the children, that would cross a line in my view. But simply looking through the driver's window at the driver who might be caught breaking the regulations, for example, using a mobile phone whilst driving, those are going to be perfectly fine. For two reasons. One, as I've mentioned previously, reporting it to the police is going to be perfectly fine, but also the general nature of filming would likely come under a journalism exemption. Because specifically with cyclists that are now filming to upload to YouTube, there are a few out there already, and there are many, let's just call them citizen journalists. Some might call them auditors, but I didn't apply that term. One that springs to mind, and I'll have to tag him now that I have him spring to mind, is Charlie Veach. I'll tag him below if you're not familiar. That is a perfect example of citizen journalism, exactly what I'm talking about in this video. I'll tag him below. Go check out his stuff. It's quite entertaining. So let me take you now to one of the documents from the ICO. This is the guide from the ICO for journalism and media, and it has a section specifically for citizen bloggers. Now, let's distinguish for a moment between citizen journalists or citizen bloggers and general journalism. There is no specific legal definition of journalism in the data protection legislation. We just take into account the ordinary dictionary definition and meaning of the words. Now, I'm not talking Black's Law Dictionary, which pops up in the comments. Watch the comments go crazy now, because that is an American reference book by all accounts. We generally just take standard dictionary definitions of the word or ordinary meaning of the word. But when we're looking at journalism as a whole, we're either talking about a company or we are talking about individuals. The reason to address this is because there is a duty to notify the ICO if you are collecting personal information. Pause for thought for a moment. Personal information is any information or data about an identifiable individual about whom you are collecting any kind of information, which is either video footage, audio footage of them, their vehicle registration mark, their name, their date of birth, etc. Things that you probably won't get just by filming them, but certainly their image, their audio, their vehicles, etc. will all be personal data for the purposes of the data protection legislation. If you are a company collecting and processing that data, you will need to notify the ICO. You will need to register with the ICO as a data controller, as that company. However, private individuals and some relatively small or non-profit organizations are generally exempt from notification unless, for example, you are a self-employed individual and you are being paid to go out and film, and in doing so you may be collecting personal information. Then you would need to register with the ICO, and that would mean that you are operating commercially. So just to be clear about what I'm about to talk about with regard to the exemption for journalism, the exemption for journalism should not be confused with the exemption to notify the ICO. So if you are a media company processing data and you're doing journalism for which you can apply the exemption, it doesn't exempt you from registration with the ICO. So don't conflate the two. However, most private individuals will be exempt from registration with the ICO unless self-employed as a media company, which is different because if you're being paid to do the work, then you're operating commercially. If you're just out filming yourself as an individual and you might happen to get some, let's say, AdSense revenue through YouTube, That is not the same, in my view, as being paid by an individual as a commercial operation to go out and film. It's not the same thing. But either way, that only really distinguishes whether or not you need to notify and register with the ICO. And for the sake of whatever it is these days, £30 or £35, it's worth registering anyway, just so that you are registered and you can't be accused of failing to notify. But all that said, we then come to the application of the exemption for journalism as it applies to individual citizen bloggers. The RCO says we accept that individuals may be able to invoke the journalism exemption if they are posting information or ideas for public consumption online, even if they are not professional journalists and are not paid to do so. That's the key distinction. And they provide an example from the High Court of England and Wales, which was the Law Society and others against Kudowski. This was where the High Court looked at a website set up by an individual to name and shame, quote, solicitors from hell. The court was clear that the private individual can engage in internet journalism. Journalism is that protected by Section 32, involves communication of information or ideas to the public at large in the public interest. Today, anyone with access to the internet can engage in journalism at no cost. If what the defendant communicated to the public at large had the necessary public interest, he could invoke the protection of journalism and Article 10. Article 10 being the freedom of expression. The ICO goes on, of course, that doesn't mean that every blog or comment posted online will be journalism. In many cases, people simply intend to take part in normal social interaction or recreational internet use. Individuals posting personal blogs or comments online that were not intended in the public interest journalism might instead be able to rely on the domestic purposes exemption in Section 36. In other words, if it's your own household activity, you're chatting away online and you publish something that is not necessarily journalism, that is just social interaction online, and you have a general domestic purposes exemption, not to be confused with the journalism exemption. But then we do move on to look at the journalism exemption, and there is a code for applying the journalism exemption itself. And the broad test is that if you are collecting and or processing personal information, for example, somebody's vehicle registration, their visual appearance, their voice, and so on, if you are doing it for the purposes of journalism and to comply fully with the Data Protection Act, for example, either have their consent or you're in a contract and some other legitimate reason for using their information, if that is incompatible with the journalism purpose of your collection, then you can apply the journalism exemption. It's an exemption from complying with bits of the Data Protection Act because it is not reasonable or compliance is incompatible with the purposes of your journalistic activity. And then it goes on to explain that using personal information for journalistic purposes, you should interpret it very broadly, applying a very broad everyday meaning to the word journalism. And journalism is one of the special purposes within the data protection law which invokes this exemption, which could include artistic, literary, academic purposes, or broadly any other kind of purpose for which you are going out and filming. And so, for example, if your journalistic purpose is filming how badly people drive as a cyclist or a citizen or whatever, or even if you're in your vehicle and you're using a fixed camera in your vehicle as you drive around, such as a dash cam, and you publish it to document journalistically how badly other people drive, you can apply the broad journalistic exemption and thus disapply much of the data protection legislation. If you are an individual, you're not being paid to do so, then in my view, you are an individual and you don't necessarily need to register with the ICO. If you are being paid to do so, then you're better off registering with the ICO. I don't, in my view, believe that that extends to things like AdSense revenue, which you might just gain from the video that you publish online, because you're not directly being paid to go out and film and you're not being paid to publish it. You are generating commissions off the intellectual property that you've derived, because you will own the copyright in the video that you've produced and uploaded, and either any skill and know-how in filming it or putting it together afterwards. Much like my videos here, I'm not being paid to produce these, but I'm using skill and know-how to edit and put them together and publish them. And so this goes on. Journalism is not limited to professional journalists or media organizations. For example, members of the public may carry out journalism, typically online. This is known as citizen journalism. The exemption can also apply when you use personal information for journalism, as well as other purposes. For example, a campaign group can use personal information for both journalism and campaigning. And so if you are acting with a view to publication of the journalistic material, so if you're a cyclist filming bad drivers and you wish to put it online for journalistic purposes, the public interest is simply how people drive. Are they breaking the law? Are they driving well? Are they driving badly? This says where you use personal information for journalism with a view to publication of journalistic material, the exemption can cover all the personal information that you collect, use, or create as part of your journalistic activity, both before and after the publication, regardless of whether you actually publish it. You publish material when you make it available to the public, even if it's not accessible to everyone. So, for example, there's a paywall. So I have a website, BlackBeltBarrister.com, where I've got some exclusive content where I will go through individual stories and things like that to break them apart, which I'm only going to make available to those behind my paywall. That also helps me to continue developing this channel. Reasonable belief. You need to have a reasonable belief that the purposes of your journalism concerns that there's a public interest in the publication and that complying with the Data Protection Act or part of it is incompatible with that journalistic purpose. In other words, if you needed the driver's consent before you film them doing something wrong, that's incompatible. So you can disapply it. You can just film them without their consent, even without their knowledge, and even if they object to it, and you certainly don't need to be in contract with them or anything else. It is incompatible, therefore you can apply the journalistic purpose. Having a reasonable belief, this goes on to explain, includes forming your own view on the points that we've just discussed. But you should be able to justify it. So in the ways that I've just described, a driver is going to object to you filming them while they're doing something wrong. So you can quite easily explain and justify your view that it is incompatible to get their consent or any other legitimate reason for filming them and gathering their personal information. But very broadly speaking, if you film them like that, there's not a great deal they can do about it if the exemption applies and you can justify it. The public interest test that you should also apply is, as usual, considering all of the circumstances and a balance between the factors for and against publication and justifying how that this is to be served to the public and judging how the public interest is proportionate to what you're filming. So, for example, if you were to film something initially with the purposes of journalism in mind and you happen to catch something that really you should question whether there's a reasonable expectation of privacy. For example, a child who may be ill or something else in the back of a vehicle and you have filmed them and they're very young, then you should really balance all of the circumstances, because there will be some cases like that where a court might find against you and find that there was a reasonable expectation of privacy and that you've gone beyond, even though you're applying the exemption, you've gone beyond what is in the public interest to publish, etc. So hopefully that serves the point. But hopefully now you can see also how that is significantly different from a fixed static CCTV camera at your home premises, filming what should be within the curtilage of your property, and if it captures anything outside, why you do need to comply with the data protection legislation, which includes subject access requests. So I hope that is useful. Do leave your questions, your comments, your debates, and everything else in the comments box below. Make sure you subscribe. As I say, around 70% of you don't do that. I'd be very grateful if you did. It's the one way I can grow my audience and the one metric that YouTube uses among probably 80 billion other references to know whether to promote my videos to others online or not. So thank you for doing that. Thank you for watching, and I'll see you next time.